once you apply for adjustment of status, you've indicated immigrant intent. And that's inconsistent with the terms and conditions of a student visa. This video is specifically about adjusting your status after entering the US as a student. I've done several videos about entering as a tourist and whether you're in your lawful tourist duration of stay or you overstay, you can subsequently marry a US citizen and apply for adjustment of status. And I've done a ton of videos on that, but it occurs to me that I've never done a specific video that discusses issues that students might face. So that's what this video is all about. For those of you who are new to my channel, my name is Puyan Darian. I'm an immigration attorney with an office in New York, but I handle these marriage-based green card cases nationwide. And I have a lot of clients who've entered as students and are now trying to adjust their status through marriage to a permanent resident or US citizen. And marrying a permanent resident has certain additional complications that I'll discuss later on in this video. So if you're gonna marry a US citizen, the stuff I say earlier in the video is more applicable to you. One of the first things that I wanna talk about is non-immigrant intent. When you enter the US as a student, during your entry, when you're dealing with customs and border protection, or even if you enter with global entry or something, you must have non-immigrant intent at the moment you enter, which means you cannot secretly intend to permanently live in the US at the moment of entry, or at least during that entry. You can't have this fraudulent intent. You must intend to leave the US after entering as a student. However, after you enter the US as a student, if you change your mind after circumstances change, you can still apply for adjustment of status from within the US. That is perfectly legal. But one of the questions that people often ask me, that a lot of my student clients ask me, is how do I maintain my F1 student visa or other student visa if I'm applying for adjustment of status? And there's a lot of misinformation specifically on this point. I've heard people say that they have to maintain their F1 in case the adjustment of status application gets denied. They want to have a backup plan. But that's not entirely consistent with immigration law. In fact, the moment you submit an I-485 application for permanent residence, technically speaking, you are no longer in a valid student visa. Once you apply for adjustment of status, you've indicated immigrant intent. And that's inconsistent with the terms and conditions of a student visa. While it's true that your school probably won't find out that you have an adjustment of status application pending, and USCIS or customs, they won't specifically send out any notification saying your student visa is now invalid. In fact, most people will probably just keep attending school in compliance with what they're supposed to be doing with the student visa, and that's fine. But technically speaking, once you submit an adjustment of status application, you are no longer complying with all the terms and conditions of your F1 student visa. So let me give you a quick example. You enter on a student visa, and then you apply for adjustment of status, and then you try to travel internationally on your student visa. You don't have advanced parole, you don't have any separate permission to travel internationally. If you try to travel on your student visa, you probably won't be allowed back into the US, because when you try to enter, they'll see that you have an adjustment of status application pending, and they'll say you don't have a student visa anymore, and they might cancel that visa right there in the airport and put you on a repatriation flight back to your home country. So that's a huge risk. If you want to travel and you have a student visa and an adjustment of status application pending, the only reliable, well, not even reliable, the only way to do that is through advanced parole. I was gonna say the word reliable way to do that, but it's actually not even reliable. I wouldn't travel on advanced parole if you can avoid it, because when you travel on advanced parole based on a pending adjustment of status application, there's no guarantee that you will be allowed back in. On that note, there's no guarantee you'll be allowed in on a student or tourist visa either. The chances are pretty high, but with advanced parole, it's a purely discretionary determination made by the customs officer. So once you submit that I-485 application, my general advice is prepare to remain continuously in the United States until your green card is approved and the physical card is in your hand. Before that happens, don't make any travel plans. A common question that people who are on their F1 visa and have finished studying and are now doing like their OPT or something comparable, I have like a year left of my OPT, I like my job. If I apply for adjustment of status, can I keep working here? And the short answer is, the moment you apply for adjustment of status, you're no longer in a valid F1 visa technically. No one will tell you this unless you try traveling internationally. Your school won't find out, your employer won't find out, at least currently. You won't receive any notification from USCIS saying that your F1 or student visa is being canceled or terminated. But technically speaking, if you continue working, it would be engaging in unauthorized employment. Now, when we apply for adjustment of status, we also apply for an EAD most of the time, an employment authorization document, like a work permit that's unrestricted. You don't have to work for one specific employer, doesn't need to be related to your field of study, but it can take a few months for that to arrive. And currently, marriage-based adjustment of status cases can go start to finish in like less than 3 months. And it's possible that an EAD won't even have time to get approved in that period of time. Like, you might be in an F1 status, marry, apply for adjustment of status, and 3 months later just have your green card. And by the time you get your green card, it won't really matter what happened previously with any like minor periods of unauthorized employment. But on your I-485 application, it does ask, have you ever engaged in unauthorized employment? So this is just something to keep in mind. There are usually no immigration consequences, especially if you're married to a US citizen. Any unauthorized employment will not be used against you, at least currently, if you're marrying and applying for adjustment of status in a one-step adjustment of status to a US citizen. If you don't know what that last phrase means, check out my other videos on doing one-step adjustment of status versus preference category. I'll also discuss that briefly at the end of today's video. So just keep in mind that technically speaking, if you continue working while your adjustment of status is pending, but before you get your EAD, I would consider that to be unauthorized employment. One of the key things I like to discuss with people who are here on a student visa and have like a US citizen, fiance or boyfriend or girlfriend or some version of that, and they want to apply for adjustment of status eventually. They don't know exactly when, they might not even be engaged yet, but like down the road, they know that this is a real possibility that they might end up marrying a US citizen and applying for adjustment of status, but they don't currently have that intent. If you don't currently have non-immigrant intent, then you can properly enter the US with your student visa. But how do you time it? And I think the best way I could explain this point is with a series of examples. Let's say you're in the US on your student visa and you marry your US citizen spouse. Now you want to travel and go back home, see your parents, and re-enter the US in the future. On your student visa, you're still studying, you might have a couple years left or whatever, and you want to re-enter the US. I think that's a slightly riskier situation than somebody who doesn't plan to travel internationally and just marries a US citizen on their student visa. And the reason is because when you enter the US, you might get a bad customs officer who asks you a bunch of questions like, where are you staying? Who are you staying with? Are you married? Are you single? Are you engaged? It's possible for them to ask these questions. And if they do, and you say, yeah, actually I'm married to a US citizen and I want to apply for a green card in the future, that would be a red flag. That customs officer's job is to make sure you're coming here to study and you have non-immigrant intent. But you just told them that you're married to a US citizen and you have immigrant intent. Maybe you didn't specifically say you have immigrant intent, but if the officer believes that during this entry you plan to apply for adjustment of status, they should deny your entry. So that's something to keep in mind versus somebody else who enters the US on their student visa, A year later, while they're still in the US, they decide to get married. And then after they get married, they decide they want to apply for adjustment of status and they never leave the US. That's a much cleaner situation. You're not taking the additional risk of traveling internationally and having your intent questioned when you try to re-enter the United States. Generally speaking, it is my preference that you don't do anything that suggests immigrant intent within 90 days of entering the US as a non-immigrant. For example, if you're planning to marry your US citizen spouse and you're on a student visa, but you're not sure if you want to apply for adjustment of status, so you properly have non-immigrant intent, you can legally do that. You can marry your US citizen spouse. But if you are about to travel internationally and come back, and it makes no difference to you whether you marry before you travel or after you travel, it would be better, in my opinion, to get married after you travel so you don't take additional risks in the airport where the customs officers improperly believe that you have immigrant intent. And in this example, you actually have non-immigrant intent. You want to get married, you're not sure you want to apply for adjustment of status. Maybe your US citizen spouse and you might want to live abroad for a while, do the whole green card process through the consulate versus adjustment of status within the US. I'm just talking about intent issues for adjusting status within the US. So generally speaking, I would prefer you get married after your last entry where you're just good staying in the US continuously until you get your green card, and wait at least 90 days after your most recent entry as a non-immigrant before you get married or apply for adjustment of status or do anything really that suggests that you have immigrant intent. All right, guys, there's one more thing I want to talk about, but I understand that this only applies to a tiny percentage of people. So before I get to it, I just want to say, if you yourself plan to marry a US citizen, or if you're a US citizen and you have a fiance or significant other who's in the US on a student visa, just know that I like to focus on marriage-based green cards where non-immigrants or people who overstayed apply for adjustment of status through marriage. So if you need any assistance with that, please reach out directly to me. My information to schedule a consultation, the link is directly in the video description below, and I would love to speak to you, and if you want, assist you with your adjustment of status case. So the last thing I want to talk about is when you plan to marry someone who's not a US citizen, but rather a permanent resident. This is a little bit complicated, and I'm gonna explain why. So in addition to all those other things I mentioned, you also have to be aware that you cannot file the I-130 and I-485 at the same time in this type of situation, at least not in September 2025. There have been times historically where the visa bulletin indicates that spouses of permanent residents are current, which means a visa is immediately available. And in those rare instances, like this happened during the COVID pandemic, there was like a 1-year window where marriage to a permanent resident provided a visa immediately. And in that situation, you were able to do a one-step adjustment of status where you file the I-130 and I-485 concurrently. But right now, as of September 2025, there's like a 3-month backlog. So you would need to file the I-130 first, wait a couple months, maintain valid non-immigrant visa status during those couple months, and then apply for adjustment of status if you want to apply for adjustment of status. There's a couple other things you need to keep in mind. So if you're gonna do a preference category adjustment of status like this, be sure to speak with me or an immigration attorney before you make some sort of mistake, because if you submit your adjustment of status application, going back to the beginning of the video, you are no longer a student. You don't have the intent of a student. And if your adjustment of status application gets denied, there's a chance that you will be placed into removal proceedings. So ordinarily, the consequences might not be that high, but right now, it could be devastating if your application ends up getting denied. So you have to do it the right way, and you might only get one shot at it before you end up in deportation proceedings. All right, guys, that brings us to the end of today's video. If you need any immigration assistance, schedule a consultation directly with me. My information is in the video description below. If you want to stay up to date with all the changes to immigration law under the Trump administration, or just some tips and tricks on how to do your application and petitions by yourself, be sure to subscribe. I'll put out several videos each week assisting the immigrant community on these issues, and I'll see you guys next time for another video.